Russian economic market today is very attractive for many foreign citizens, who sometimes make many mistakes when importing goods into Russia. In this video, I will help you figure the following questions out. My name is Vasily Tarasenko. I'm a Russian attorney, so let's start. Questions to discuss for today. What goods are forbidden to be imported by the individuals and legal entities into Russia? What permits must you obtain and import goods into Russia? What is the customs clearance of the goods and what is the liability for non-declaration of goods? Number 4 is, how do I declare goods right to import them into Russia? And number 5, how much do I have to pay for importing goods and what problems may arise when crossing the green channel with goods subject to custom duties? So let's discuss step by step. To begin with, I would like to designate goods that are currently prohibited from being imported into Russia. It's a fire, gas, air and edged weapon as well as their components and ammunition. Second is endangered representatives of flora and fauna. Third, pornographic photo, video and printed products as well as any things that include components of state secrets, also incitement to racism, extremism, hatred, etc. Number 4 is non-certified fruits and vegetables. Number 5, drugs. And number 6, organs, tissues, blood and its components. In case of violation of those rules, one can incur administrative or criminal charges. In the Administrative Code of Russia Federation, there is a chapter number 16, which provides for customs offenses. Let's talk about these in more detail. So, first of them, concealment of goods by using receipts or other methods that make it difficult to detect goods or by making some goods look like others. Second one is false declarations or non-declaration of goods. Also, non-observance of prohibitions or restrictions on the import of or export of goods. Also, false declaration of cash and or monetary instruments. Also, movement of goods, vehicles or persons across the border or conducting business activities without permission. Also, storage terms violations, as well as failure to export temporarily imported goods or vehicles within the established time limits or vice versa, failure to re-import temporarily exported goods. Assignment of the rights to use or dispose vehicles temporarily imported by other individuals without complying with the customs legislation, and other cases provided for by the Administrative Code. These were all types of administrative liability, but what violations lead to criminal charges? Let's discuss this one. First of them is the evasion of customs duties, also smuggling or cash, monetary instruments, alcoholic or tobacco products. Smuggling of any poisonous and explosive substances, firearms and other weapons. Also smuggling of narcotic drugs, psychotropic substances, plants containing narcotic substances, as well as any other equipment used for manufacturing narcotic drugs. In our practice, we often get calls from foreign citizens who didn't declare goods when the duty-free limit was exceeded. In this case, such persons are given an administrative fine in the amount of from 50 till 200% of the value of items. Also, they may face confiscation. One more item that I would like to discuss is that to declare the goods, you need to meet the clear requirements that are spelled out in the decision of the Plenum of the Supreme Court of October 24, 2006, number 18. Namely, when declaring a consignment, provide information about all the items, not just one, even if they're all the same. The information in the declaration must match the items that are presented for customs clearance. Compliance with these conditions will help you quickly and easily complete the declaration of goods for import to Russia. Mainly customs declaring can be done in electronic form, yet it is done in written. If goods undergoes the customs transit procedure, if the goods are for personal use or you are going to transport them in international mail, if these are international transportation vehicles, when using transport, commercial and or other documents as a custom declaration, including those provided for by international agreements between the member states and the third party. In other cases determined by the European Economic Commission and the legislation of the member states. There are several declaration types. They depend on customs procedure and persons moving those goods. Goods declaration, transit declaration, vehicle declaration and passenger customs declaration. Just 4 types. As a goods or transit declaration, one can use transport, commercial or other documents containing information necessary for the release of goods. The Eurasian Economic Commission can require you to fill in a declaration about customs value, amount and conditions of the transaction with goods. This is an integral part of the goods declaration. In our legal practice, there were very often cases when the applicant provided false information in a customs declaration, for example, an incomplete declaration of the goods, its quantity, properties, name, and so on. It is important to understand that such errors can be regarded as an attempt to exempt from custom duties or to reduce their size. All these can lead to a fine or confiscation. But if the false data in the application didn't affect the cost of customs duties in any way, one cannot be administratively liable for this. In all the above cases, the lawyers of our company will help to file a complaint with the judicial authorities against decisions, actions, or inaction of the customs authorities and their officials, including appealing the experts' conclusion on the imported goods, also to return the goods as illegally confiscated. So don't forget to subscribe to the channel and leave feedback. My name is Vasily Tarasenko. I wish you all the best. Bye.